that in dealing with Rule 52B, the court exercises original and discretionary jurisdiction, and that exercise does not constitute an appeal from the judge's disposition in earlier decisions regarding the nature of its powers to issue interlocutory orders pending the determination of an appeal. Can an application challenging the orders of the Court of Appeal under Rule 52B be regarded as an appeal for the purposes of Article 1634A? In almost all the cases where the Supreme Court has been called upon to invoke its jurisdiction under Article 1634A of the Constitution, the Court has almost invariably proceeded on the assumption that there exists a substantive determination of a legal or constitutional question by the Court of Appeal which the intending appellant seeks to impugn. Indeed, in general, this is the rational meaning to be ascribed to the word appeal in an adversarial system where jurisdiction is assigned by the legal norms to a hierarchy of courts. Rule 52B of the Court of Appeal Rules of 2010 is derived from Article 164(3) of the Constitution. It illuminates the Court of Appeal's inherent discretionary jurisdiction to preserve the substratum of an appeal or an intended appeal. Although we would not go as far as describing such discretionary jurisdiction as original, because in our view the term inherent more accurately captures the nature of that jurisdiction, the Court of Appeal has nonetheless defined the contours of this discretion succinctly and consistently, and has employed it effectively to aid the conduct of its appellate jurisdiction. We would draw a parallel between the exercise of the Court of Appeal's power under Rule 52B with the inherent powers of this court to grant interim reliefs, with particular reference to our decision in the Malcolm Bell case. And we have cited some of our statements. I don't have to read that. The general stance of the law, therefore, is that there will be a pending or an intended appeal as a basis for this court to entertain an application for stay of execution or for grant of an injunction. We have found the statement of legal principle as stated in the Malcolm Bell case regarding the inherent jurisdiction of this court to grant a stay of execution or injunction so as to preserve the substratum of an appeal or intended appeal. Again, we have cited various cases where this court has had to deal with the issue. The application before us relates to the exercise of the Court of Appeal's inherent discretion under Rule 52B and is to be distinguished from instances when this court has dealt with appeals arising from interlocutory applications originating from the High Court through to the Court of Appeal and finally to this court. In the Joho case, for example, we had and determined an appeal emanating from a substantive determination by the Court of Appeal of a constitutional question. This application triggered the appellate jurisdiction of this court. Not only had it sought to contest a substantive determination of a constitutional question by the Court of Appeal, but the issue in dispute to the Court of Appeal, even though the substantive appeal on the election petition outcome was still pending before the Court of Appeal. The application before us contests the exercise of discretion by the appellate court when there is neither an appeal nor an intended appeal pending before this court. Moreover, the appeal before the Court of Appeal is yet to be heard and determined. An application so tangential cannot be predicated upon the terms of Article 163(4) of the Constitution. Any square involvement of this court in such a context would entail comments on the merits being made prematurely on issues yet to be adjudged at the Court of Appeal, and for which the priority date of 22nd September has already been assigned. Such an early involvement of this court, in our opinion, would expose one of the parties to prejudice with the danger of leading to an unjust outcome. In these circumstances, we find that this court lacks jurisdiction to entertain an application challenging the exercise of discretion by the Court of Appeal under Rule 52B of that court's rules of 2010, there being neither an appeal nor an intended appeal pending before the Supreme Court. We, in this regard, again embrace the perception of Chief Justice Marshall of the U.S. As long as 1821, when the learned judge stated as follows: "It is most true that this court will not take jurisdiction if it should not. But it is equally true that it must take jurisdiction if it should. We have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. The one or the other would be treason to the Constitution." The Deputy Chief Justice will read the orders flowing from that analysis.
I expected my brothers to do the finality, but let me give you the foregoing, the orders emanating from the foregoing analysis. In our opinion, the foregoing analysis bears a clear direction and must culminate with the following orders, and that is, there are our orders. 1. The preliminary objection dated 11th August 2015 is allowed. 2nd, the application dated 3rd August 2015 is disallowed. The applicant shall bear the cost of the first and the second respondents, while the third and the fourth respondents shall bear their own cost. And these are our orders. Thank you very much.
Yeah, very good.
Please, there is enough time for you to rejoice. Okay? Thank you.
I was craving the indulgence of the court to, on behalf of the bar, to thank the Supreme Court and to acknowledge that indeed the Supreme Court interrupted the court's vacation to come and listen to my friend's application during the vacation. And we are very, very grateful indeed. Thank you.
Thank you very much.
There are times when the court goes beyond the call of duty.
Thank you. Thank you. We appreciate your. If there is nothing else, then the court adjourns.
All rise.